All right, second courthouse in one day, but we'll go forward with it. So we're ready for State versus Eric Lavoy Henderson. And if I don't, I've read through all of the pre-sentence reports. What if I don't agree with that? How long has he been in jail? All right, so Mr. Henderson entered a plea to the fourth offense, driving under the influence, and he also then entered a plea to 3 counts of attempted aggravated assault, and then the other charge was being in possession of a firearm by a convicted felon, a Class C felony, and that carries 3 to 6 years. So what are you agreeing to? That microphone on.
Sorry. I'm not used to having nice things. Time served, balance on state probation. I do believe because of the because of his prior conviction and the felon in possession, he would be on probation, but it would carry an 85% if he ever did violate. So 6 years at 85% should he violate, with credit for roughly 6 months in jail.
You know how many prior convictions he has?
It's a lot.
41.
I did not know it was that much.
I don't think I can agree on that.
But we can have a hearing, Your Honor. That's fine.
I think 3 counts of attempted aggravated assault and a fourth offense, driving under the influence, and a possession of a firearm by a convicted felon with someone who has 41 prior convictions, according to the pre-sentence report. I don't think I'm doing my job if I approve that. So we'll have a sentencing hearing. If you need a moment to prepare for that, we can do that. I would go ahead and take up the next case, which is the sentencing hearing on William Brent Jones. Are we ready on that one? If you look at the pre-sentence report, I'm not saying there are 41 felonies, but there are 41 separate convictions starting. He has a violation of probation 2015 on DUI. He has a 2014, I'm reading from the pre-sentence report. In 2014, he has a driver's license, DUI, driver's license revoked for 2 years. 2013, prohibited driving under the influence of an intoxicant. 2012, he has 30 days suspended on driving with revoked license. He then has prohibited driving under the influence of an intoxicant. In 2012, he has theft. 11/29, 2011, he has a not defined, but he was revoked to serve 60 days in jail. 2011, he has reckless driving for 6 months. 2010, he has 60 days in jail for assault. 2010, he has theft of property, 2 years suspended. 2009, he has 60 days in jail on vandalism. Another 60 days in jail on harassment, same year. 2005, he has evading arrest, time served. 2005, he has time served in jail on resisting a stop, frisk, or halt. 2004, he has possession of drugs. 2003, driving while impaired. 2003, resisting arrest. 2003, vandalism. 2003, evading arrest. 2003, death of an employee caused by a violation of standards. Not sure exactly what that one means. 2000, he had evading arrest. 2000, he had 30 days in jail for driving a revoked license. 2000, he had 6 months in jail for resisting stop, frisk, halt, arrest, or search. 1999, he had evading arrest. 1999, he had driving under the influence. 1999, evading arrest. 1999, driving on suspended license. 1999, kidnapping. 5 years suspended to probation. 1998, driving on a suspended license. 1998, driving with his license suspended. 1997, 10 days in jail for theft. 1997, 30 days in jail, 30 days suspended for criminal impersonation. 1997, evading arrest. 1997, reckless endangerment. That was 11 months, 29 days. 1997, theft of property, 1129. 1996, theft, 1129. 1996, theft, shoplifting, 10 days in jail. 1996, $25 fine on driving on a license suspended. 1996, 30 days in jail suspended for theft of property by shoplifting. 1994, aggravated assault, pled to simple assault. That was 1129 suspended. Then there was 1986, harassment, and 1983, disturbing the peace. So, well, I will allow you some time to check that out, but I'm of the opinion that in the view of that, which the pre-sentence report is designed to give me the background on an individual so I can make a proper determination. And under those circumstances, I just feel like I'm not sure that the state had all of the information that was given to me in the pre-sentence report, and I wanted to bring that to your attention. I will pass this and go on to the next case so that you have an opportunity to.
I've read the pre-sentence report. I obviously didn't really read it that closely, but I have a copy of it. Mr. Poland's client isn't here, so I don't know how much time they need to discuss.
You need some time to talk. Well, we can start the hearing. I'm not, Mr. Willoughby, I think you know me well enough to know that it's rare that I step into the middle of any kind of thing.
And I understand.
Where someone entered a plea and went to a sentencing hearing, then it's my responsibility, and it's not, while I usually will allow the parties to agree on something, I think it's more important for me to do what I think. We're ready.
I would move the pre-sentence report as an exhibit.
Well, then are we going to go ahead and start this sentencing hearing? Is that correct?
That would be my suggestion.
All right, then we were ready to start. This is the state versus Eric Lavoy Henderson for sentencing.
The state would only have argument. I mean, as the court's already noted, I do believe for enhancement factors, number one certainly would apply. There's no reason.
Let me stop you for a moment and just say, so what we're doing at this point is introducing the pre-sentence report as Exhibit 1 to this hearing.
Yes, Your Honor.
And Officer James is here. Is there any need to put her on the stand to authenticate the report? You can call her as a witness if you want to question her. Do you expect to do that? All right. I'm going to have this investigative report, pre-sentence report marked as Exhibit 1. Now, I'm sorry. Then the state have any other proof?
No, just argument.
I think he wants to put his client on the stand, and we'll deal with the argument. Then Mr. Henderson, if you're wanting to put your client on the stand, is that correct? I see you're our only witness. All right, then Mr. Henderson, if you'll come around over here. Ask you to raise your right hand and let me place you under oath. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
Good afternoon, sir. Will you please introduce yourself to the court?
My name's Eric Lavoy Henderson.
And when were you born, sir?
January 27th, 1964.
Now, I'm just going to get right to the meat of everything because as you came out, we were learning that you were told that the state made an offer that you would be sentenced to time served.
Yes, sir.
And the court is not accepting that offer. And
Okay.
part of the court's job, in large part, is to ensure community safety.
Yes, sir.
And when, as you just heard, the court read over 41 offenses going back to 1983. Now, I had no reason to question any of these offenses,
Well-
but you whispered in my ear that some of these are not you.
Yes. Well, what it is, me and my son, we got the same last name, and which he's a second, I'm a first, and we had this trouble before where they had me and him. We got our charges crossed somehow or another, and they tried to arrest me one time, which he was wanted by the police, and they finally got that figured out. But they've been getting my between my birthday and his or something in between our charges. They've been just getting both of them confused.
Okay, so I think the best thing to do, and you took an oath with regard to your honesty, all right?
Yes, sir.
You acknowledge that you do have a criminal history,
Oh,
correct?
I do. Yes,
Okay.
I do.
So I'm going to
Yeah.
do something similar to what the court just did with regard to reading out your charges. And you let us know whether that was you or not. I mean, please
Well-
remember, you are under oath.
Yes.
So if it comes back that you're not telling the truth with regard to anything,
know.
there could be greater consequences. So this pre-sentence report shows that well, let me go back. Your son, Eric Henderson II,
Yes.
he's no longer with us, correct?
No, he passed away June the 9th,
2019?
2019.
And prior to this recent string of arrests, you don't have anything reflected from
I
2019
can't
on?
recall a whole lot of it.
All right, so back in May of 2015, this shows something out of Sumner County. Were you living or doing anything around Sumner County back in 2015?
I think I've got a DUI in Sumner County.
Okay. And then a possible violation of probation on that DUI?
I don't think I did. I think I finished up my little school thing up there and whatever they told me I had to do.
Okay. What about Davidson County in 2013? There was a driving while under the influence of an intoxicant. That was probably your second DUI.
That was probably my
Okay.
second DUI. Yes, sir.
And then you also had, I think, a DUI in Davidson County in 2012.
Sounds about right.
Okay. Looking at some of these, some of them may be related to one another. In 2012, when you had the DUI, was there a theft also involved with that?
I can't recall no theft. I don't
Okay.
even know what that'd be for. Really don't.
Did you get in trouble in Williamson County in 2011?
It was me and my brother got into trouble.
Okay.
He went to Kmart and grabbed some jewelry or something out of a case, and since I was there, they charged me with it too.
Okay. And then in 2011, you got a reckless driving.
Sounds right.
And what about in Davidson in 2010? An assault?
2010.
Mm-hmm.
Didn't tell you that.
Okay. And just so we get an idea, so we don't look back too far, your son, Eric, how old was he when he died?
33. 34?
33?
34,
Okay, so
maybe. He's
if
been gone for 6 years now.
so he would have turned 18 somewhere around 2005? What year was he born?
84.
Born in 84.
April
2002.
30th.
2002 is when he would have turned 18. Just so I know we're looking at the appropriate
Okay.
times here. Would you have got, so the Williamson County thing in Kmart, we see actually may have happened in 2010.
That sounds about right.
Theft of property, you had 2 years suspended, and then I'm guessing in 2011, that's when you wound up doing 60 days on that?
I think so.
Okay, so those were connected.
Yes, sir.
All right. A vandalism charge from 2009, makes sense? Where you got 60 days in custody in Davidson County?
Vandalism. Be truthful, I couldn't tell you for sure.
Okay.
I'm not going to deny it, but
What about a harassment charge in 2009?
I don't know.
Seems to be from the same date, 4/23/2009. Harassment and vandalism.
That's when me and the old lady was arguing or something.
Okay. So something, it sounds about
Yes,
right?
yes.
Okay.
That's a possibility.
Then let me
Yeah,
ask
a lot
you
of
about this one charge in which the court didn't know what it was. It said death of an employee caused by a violation of standards. Was that
No.
related to you?
No.
Okay, because
Death,
that's when you said something
You
to
talking
me.
about a death, you say?
That's what I'm,
No, I ain't never hurt anybody ever in my life.
okay. And
No, I ain't been in a fight with nobody, and
Okay,
especially the employer.
I don't think that's what's being said here. Did you ever see anybody die while working, or was there ever a death related to any legal work that you were doing?
No.
Okay, okay.
No.
And I think that definitely caused a little bit of confusion for the court,
Yes.
where the judge even
No,
said,
no.
I don't know what that's about. So you don't know what that's about?
None of that whatsoever.
Okay. All the other stuff, was there anything else that you heard that the court was reading off that may have stood out to
All
you
that-
that
all
I don't
that
think
what
this
is
was
reading
me?
off, it's been so long ago. I'm just trying to get behind all that. I'm trying to be a better person. I've stopped drinking and I've started doing a lot of things, and I've been talking to God, and I just figured that drinking was getting me in so much trouble. And I've been clean and sober for over a year. I was clean sober over a year before I even come back to court last time. So just talk to God and do what I got to do. That alcohol was running my life, and I figured out, I asked God, and He got me away from it. So I don't think about it. Don't even think about it anymore.
So let's go back a little further. And thank you for letting us know that. The majority of these crimes, do you agree and acknowledge that you have a criminal history at least dating back to 2003?
Probably, yes. Sir.
Not 2003, but 1983.
Yes, yes.
Okay. And you're just mentioning alcohol. Are you telling us that alcohol played a large part?
Alcohol was playing the most valuable part of my life. It took me down through it. It ruined my life. I mean, I knew I had to do something about it, and me getting off of it and staying away from it.
Hold off on letting us know how you stopped drinking. But when you were drinking, how often were you drinking?
I was drinking at least, I get off of work and I drink at least a pint or two a day, just about every day.
Pint or two of beer or?
Probably vodka or something like that,
So something hard.
something hard.
Now, this criminal history that's on the pre-sentence report, that shows that in 2015, you stopped committing crimes, at least until this recent string of
Yes.
arrests. What happened there?
That I couldn't tell you really, to be honest with you.
Did
don't
you
remember.
straighten up for,
I try to be straightening my life out.
were you still
know.
drinking?
I think I was on the verge of quitting at that time, or maybe I did try to quit that time, but I didn't succeed to do it.
Okay.
But, this last time, I mean, like, I was just getting in too much trouble and stuff. And alcohol, I think it's been the biggest part of my life of, getting in this and getting in arguments. And I figured I got to do something. I turned to God. So I'm like, help me out. I mean, I need help. So after that, I'm doing good. I mean, I thought, they tell me to go to AA meetings. I went to AA meetings. AA meetings didn't do nothing, just make me want to drink. I'm like, no, that don't sound right. So as long as I stay away from people.
So you seem very intent on telling us about your version of how you got to sobriety. So let's just go there, and then if there's anything else we need to uncover, we can do that. Did you decide that you wanted to get sober after your last arrest?
Yes.
All right, and please tell the court what that arrest was for, if you remember. Was that a DUI fourth?
I think the DUI, the last DUI, yes.
Okay. And you already had 2 other pending charges during that time?
I did.
Am I right?
I did.
All right, and your bond was not revoked during that time?
No, sir.
All right, so you're telling us it was after that arrest you decided to get sober. So was that March of 2024?
It was.
Okay. And did part of your desire to become sober have anything to do with you wanting to get back with your ex-wife?
A little bit of that too.
Okay.
Yes.
Did she put any conditions on you?
No, she did not.
No. Did
She
she
told me I need to change my ways, stop drinking and all that. And I'm, just for her, I'm good with it. I ain't got no problem with it.
Was she ever coming by and inspecting your house to see if you were drinking?
He's been there a time or two, yes.
Right.
Yes.
Was she trying to catch you to see if you were drinking?
Obviously, probably so, but,
Did she ever catch
she
you?
took my word, a lot of it she took my word for. But I quit drinking. I mean, I just had enough of it, period. I would get off of work and I would go past the liquor store. I wouldn't even look over toward the liquor store. I'd just keep on going and ask God, just keep me away from this crap.
So what changed? Why did you?
So I had to change for, a lot of it I had to change for myself.
Okay.
I had to change that. I had to change for my family. I'm getting too old to be stuck in, 61 years old, and it's my time to change my life.
So now you have about roughly 18 months sober?
Be almost 17 months sober.
Okay. Okay.
Yes.
And have you noticed a change in how you feel?
I have. I get where I just, only thing I do, I talk to God all the time, and I feel better by myself. I feel better. I think I'm doing, when I'm talking to my family or something, I mean, I feel like I've changed somehow or another. I don't feel that evil in me anymore. I try to stay away from that devil part.
So when you say that evil, do you feel like when you were drinking, you had a tendency?
I had the demon in me.
Okay. Something I have to bring up. Part of your arrests were unlawful possession of a firearm as a convicted felon.
Yes.
And in one of those cases, you actually called the police to report a burglary.
I did.
And you told the police where the weapons were, weapons that you did have.
Yeah, it was a gun my son had. He had it in the corner of one of the bedrooms.
Do you understand that you are not allowed to possess a firearm?
I am. No more for me.
Any gun whatsoever?
Yes, I understand.
Okay. Do you work?
The ones they did steal, they stole 2 antique pellet rifles with the stove.
Okay.
My grandfather gave me to me when I was a kid, so it meant a lot to me.
So there was a theft.
That was the thing. They got that, and they got my mortgage money also.
It just so also happened that you had some weapons that you shouldn't have had
Yes,
at all.
That's true.
Do you work for a living?
I do.
Tell the court what you do.
I'm a plumber.
How long have you been a plumber?
About 10 years now.
Okay. Do you have employment opportunities if and when you are eventually released?
I am. I can get back to work as soon as possible.
Do you have the physical abilities to continue to work?
I think I can continue along. I mean, I don't have no choice, really.
Do you have any health conditions that you want the court to know about?
Well, I've got a bad heart. I was supposed to already had it operated on, but what it was, they put me a little monitor on my chest, and at that time, when I had the monitor on, I was supposed to wear it for 2 weeks and turn it back put it in a box. But before I got to the box, somebody stole my vehicle, and I didn't know where to send this monitor back to, number one, on that heart thing.
Okay.
So other than that,
What's your heart condition?
they said it was, I forget what it was.
Is it called
Exactly.
AFib?
It's afibrillation, is what it is.
Mm-hmm.
It got me on blood thinners and blood pressure medicine. Doctor told me, he said he can repair it, but he said he's got to find out if it's one problem or is it two problems.
Do you have any other health conditions?
No, sir. Diabetes. Other than that, I think,
Prior to the court revoking your bond, had you committed any new violations of the law?
no, sir, not at all. Just worked every day.
And you're telling the court that you maintained sobriety for about a year from March 2nd, 2024 till March 18th of 2025?
March 4th, the last day I had anything to drink.
Okay, March 4th.
Yes,
Okay. And then I know you had court on March 18th, and then you had court again March 20th of this year.
yes, sir.
And the court revoked your bond on the 20th,
They
right?
did. They
Okay,
did.
so you had nothing to drink between
No,
that time at all?
no.
And what about since you've been in jail? I know it's more difficult, but I know things
No,
happen. Have you done anything in jail?
No, sir, none,
No.
nothing.
Okay, any desires?
No, none at all.
No. Is there anything else you want to share with the court?
Right now, I really don't know what to say to the court. I mean, I'm very sorry for everything what happened and everything I have done in my past. I'm very sorry for that. I'm trying to change. I'm really trying to change. First thing is that alcohol. I got to just continue to just say no. As long as I stay away from that crap, I think I'm in good shape.
Your Honor, I have no further questions.
All right, Mr. Willoughby, you may cross-examine.
Now, you did pick up another charge while some of these were pending. You got like 3 in a row, right?
I did.
And that's why we revoked your bond.
It is.
And you said something, you said, I've never hurt anybody,
I never hurt anybody, no.
but one of the charges you're convicted of today, you pulled a gun on your daughter and her boyfriend and their child.
She wasn't even nowhere around. Her boyfriend was
How
kept,
would you know? Because hang on a second. How would you know? Because when the police showed up, you were passed out on the porch.
I was not passed out on the front porch. They kept saying I was passed out. I wasn't passed out.
Okay, well then what were you?
I was
Were you
sitting on-
sober?
I was sitting on, I wasn't sober,
Mr.
no.
Perkins,
I was
you
sitting on
move
the
that
front
microphone
porch.
toward
You're
you.
gonna have to,
I was sitting on the front porch, just sitting there, playing on the telephone.
so you didn't pull a gun on your daughter?
No.
No. But
I showed, when I was walking out the house, I did pull the gun out of my pocket and showed her boyfriend. I told him, because he kept reaching in his pants and pulling up like this, and I felt threatened. So I went upstairs and got my son's pistol. He had a pistol there on the refrigerator, so I went up there and got it.
so none of these guns are yours,
No, it belongs to my son.
but he was dead.
No, it's my other son, Jeremy.
Was he living with you?
He's in and out.
He just left guns there?
So I didn't think nothing of it. I mean, yeah,
Well, you're a felon,
yeah.
so you should have thought done something of it.
Well, he probably didn't think of it either. I wasn't thinking anything of it, because I figured it's in the country. I didn't think anything about guns or anything like that.
So they weren't your guns, they were your kids' guns, but you knew where they were.
Yes.
What were y'all even arguing about?
I'm not even really sure. I mean, I was holding my granddaughter is what it started off with. I was holding my granddaughter. and
How old is she?
Like 2. And he said, he kept saying, you drop her, I'm going to drop you. I'm going to drop you, old man, stuff like that. And
Was
I'm
he
like,
worried you were going to drop her because you were
No,
intoxicated?
yeah, that's what he was. He was afraid I was going to drop his daughter, my granddaughter, and he kept saying, "You drop her, I'm going to drop you, old man." And it just one thing led to another, and I just told him I want him out of my house. And
Did
that's
it have
how
anything to do with him being African American?
that's how all this stuff come down. Just him. I'm talking about, you drop her, I'm going to drop you, and one thing led to the next.
So you're saying it's his fault?
I'd say, well, I can't say it's his fault. All of us are sitting there drinking. I say it's my fault. I mean, I was a straight dumbass, for saying this. But
But you're sitting up here and
If I didn't invite him or her to my house that day just to come over to the house and drinks, would none of this stuff it would never happen. Never happen.
But you invited the cops over the next time and you showed them you had a gun and you're not supposed to.
Well, that's because my house got burglarized.
Okay. That doesn't mean that you're supposed to have a gun, does it?
Well, that means, no, I'm not supposed to have a gun. He just happened to look behind the door and there was a gun.
Oh, so he got lucky and found out you were breaking the law.
Yeah.
But that's his fault too.
Well, I'm not saying it's anybody's fault.
You called them out there. What were they supposed to do?
It's for a burglary charge.
I know. But what were they supposed to do? Not investigate it?
Well, if they wanted to investigate that, they investigated it.
Sure.
Okay.
And guess what they found?
A gun.
Yeah. And you're a felon.
Yeah.
I want to go back to this whole, you never hurt anybody, but pulling a gun on your kid.
I didn't pull it on my kid.
You just said you did so.
I did not pull it on my daughter. I pulled it on her boyfriend.
Okay.
One was threatening me. One was reaching in his pants, acting like he's got something in his breeches.
What's a gun made to do?
Well, if he's got one in his pocket, I
What
want
is
one
a
in one in
gun
mine.
made to do?
Shoot?
Yeah. At whatever, right?
Yeah.
To what happens when you shoot it at something?
I have no idea.
You have no idea. A bullet comes out the end and something on the other end gets hurt, right?
I wasn't planning on hurting anybody. I just want him off my property. That's the only thing I wanted, him off my property.
Did it have anything to do with him being black?
Nope. Sure didn't.
It's just, you've got a kidnapping charge and you're sitting here talking to God every day or whatever. It's just hard for me to pretend like whether or not you think you're justified in doing it, if you would have pulled that gun out and shot him.
I wasn't planning on shooting him. I didn't want him shooting me though. I didn't know what was in
Did he
his
have a gun?
pants. Huh?
Did he have a gun?
I think so.
Cops didn't
He
find
may
one.
act like he did have one. Once he left, I have no idea what he did with it.
So it's his fault that he didn't want his drunk father-in-law holding his 2-year-old daughter.
Yeah, it started off, alcohol was the problem. It was the problem.
But you got sober when?
March the 4th was the last time I had anything to drink.
Of this year,
Last year,
of 24.
24.
But these charges were before then, so
It was before then, yes.
what made that day the day?
I don't know.
And just to be clear, of these prior convictions, how many of them are you disputing? Have you looked through the whole list?
No, I have not.
But
I don't remember. I can't keep up with all that,
call it 10,
baby.
so you still got 31?
That's all in the past. That's all in the
Well,
past.
today's the day, and the past is the past, but the past matters.
Yes. That's why I stopped drinking. That's why I said, well, every time I get to drinking and stuff, I got problems. I'm drinking, I get problems. So I figured if I quit drinking and stay away from people that's drinking and all this, I wouldn't have these problems.
I guess I understand the fact that you've identified the problem, but I have trouble with the fact that you still say the one conviction you have with your son-in-law, we'll call him that.
Yeah.
Are they married?
No,
Okay, can we call him the son-in-law?
Yes.
Is that fine? That's his fault because,
I'm not saying for sure if it's his fault. We
You
was
just
all
did.
we was all drinking. I'm not saying I'll take the blame. I'm not trying to get out of none of this. I said we was drinking. We was all drunk. We was all sloppy drunk, and one thing led to another. I just, instead of arguing and whatever it was, I just told him to leave my property. That's the only thing that's what I told him, to leave my property. And all this comes down to this.
but going back to the, you said you pulled the gun out of your pocket.
He know I had a pistol in my pocket,
Why did you have it in your pocket?
because he was kept pulling in his, pulling
When
like
did you
this.
put it in your pocket? Did you just keep it there all the time?
Who, me?
Yeah.
No.
So at what point during the evening did you go put it in your pocket?
As soon as he told me he was gonna do something to me.
So you went and got a gun that's not your gun, so that's not your fault. To pull it on somebody who supposedly threatened you, that's not your fault. And then even though the police said you were passed out on the porch and you admit you're drunk, that's not true either.
Yes, it's true. I was drinking.
And the gun wasn't on the patio?
Gun was in my pocket.
Okay. I don't have any other questions, Your Honor.
Antonino, do you have other questions?
So you remember the cops coming up to your porch the night you were arrested?
I do.
Okay. And you remember them telling you to stand up?
I did.
And you remember them getting the pistol out of your
Yes,
pocket?
they reached, one grabbed me on the right side, one grabbed me from the left, the other guy reached in, got the pistol out of my pocket.
And to be clear, sorry, I was hearing something. When your bond was revoked, you were still dealing with all three of these cases in general sessions, right?
I was.
Okay. And then they went through general sessions, and then you came up to circuit court and had an arraignment on all three of these cases. You were arraigned at the same time, am I right?
Yes,
And you had the public defender at the time?
yes.
Okay. And your case was in circuit court for, is that roughly almost a year or 9 months before your bond was revoked?
At least about a year or so. It might have been over a year.
Okay. Just because
Almost two, I think.
the state brought it up, we revoked your bond because you had all these cases.
Yes, yes.
But the state didn't revoke your bond while you were in general sessions, correct?
No, sir.
And then while your case was in circuit court, you maintained your sobriety that whole time,
I
correct?
did.
All right. I don't think we could really say it any other way. Do you accept responsibility for what you've done?
I do. I really do. I mean, I'm very sorry for what I've done, but I accept responsibility for what I did do. I honestly do.
And you had a weapon in your house when you weren't supposed to have a weapon,
Yes,
correct?
that's true too.
And then the night with your son-in-law, you had a weapon that night as well, right?
Yes,
And you showed that weapon
to him, yes.
to him, but your daughter and your granddaughter were around as well.
No, they wasn't around. They was downstairs in the basement.
Well, you agree that you at least
Yes.
pled guilty to the attempted
yes,
assault.
Yes, I do.
God forbid if something happened between you and your son-in-law and
Yes.
you guys were fighting, weapon could have accidentally discharged
It
and
could have.
someone could have been horribly hurt.
Anything could have happened.
Okay.
But, yeah,
And then you acknowledge, we got this fourth DUI.
yes.
So you accept responsibility for
I
what
do,
you did.
I do.
And when you saw that you were a part of the problem and your actions of drinking on a routine basis, you did something about it, didn't you?
Yes, sir.
Do you intend to continue to do something about?
I am. I'm gonna leave it alone. I'm done with it.
I have no other questions, Your Honor.
Will be anything else? Thank you, sir. You may step down and have a seat by your lawyer. Montanino, do you have any other witnesses? Do you have any rebuttal proof you wish to offer? Reluctant witness. Ms. James, if you'll come around, please. We're going to put you over on this side. You'll raise your right hand. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God. All right, thank you.
Officer James, could you state and spell your name?
Wendy James, WendyJames.
We had a brief conversation over here. You heard Mr. Henderson talk about maybe his identity being confused with his son who has the same name. Did you hear all that?
Yes.
Do you have any explanation or justification, validation, anything like that about whether that's true or not?
I know that all of the charges I entered were correct because I verified the birth date. There were charges on there previously,
From a prior pre-sentence report?
or just prior records that were
Right.
on there from being on probation in the past where they enter those. Someone else could have entered the wrong information. The one that he was referring to over the death, that was a misdemeanor offense, 1129. So even though it was a death, it obviously wasn't something that was, intentional, that he hurt someone.
Right.
But yeah, that was the only one I actually even questioned that one myself, but I couldn't find anything on it other than what was already in there.
But on that one, his birthday was correct.
On that one,
Yes.
no, I didn't enter that one.
You did not enter
I
that
did not
one?
enter that one.
Of the total that were entered wherever before you got to enter other ones, 41's the total number. How many did you personally enter if you just had to rough guess it?
Probably 30 or so, maybe.
So again, when he was testifying and I said, let's call it 10 in dispute, would you say that would,
That could be accurate.
whether or not that's true or not, that would be an accurate number?
Yes.
Okay. I don't have any other questions.
Montanino?
You heard Mr. Henderson testify,
Yes.
and I went through and I asked him if a lot of the crimes were his charges, and you heard him say, yes, they were.
Yes.
The only one we had a really legitimate question about was that one that you were just telling us about with the death. But you indicated that some of these charges may not have been verified, or at least were not verified by you.
Yes.
So it's possible there was a mistake somewhere or some type of mistaken identity.
There's a possibility, yes. A few of the misdemeanors.
Okay, all right. God bless you, Your Honor. You made some recommendations at the end of your pre-sentence report. You didn't quite say whether he should serve a certain amount of time in jail. You just discussed certain recommendations that would be helpful for him while on probation. Is that
Yes.
right? And hearing what you heard from Mr. Henderson today, do you still think those recommendations would be appropriate?
He can actually complete those in or out of facility.
Okay.
Yes.
Do you think you would be a decent candidate for probation?
I'm not going to answer that.
I have no further questions, Your Honor.
Anything else, General? Thank you, Ms. James. You may step down. Any other witnesses? Any rebuttal proof from the defense? Then I'll hear you in argument. Actually, the state gets to go first on the sentencing hearing. They get to go first and they get to go last.
Alpha and Omega. As far as enhancement factors, Your Honor, I would argue that certainly number one would apply. He has a prior criminal history, although it's not, like I said, I only had noted 2 felonies, but that doesn't exchange the other misdemeanors, even if I think by the defendant's own testimony and by Ms. James or Officer James's testimony, we're still talking about 30 total, roughly. So I would argue that would apply. Number 3 definitely applies, at least in the aggravated assault case. It was his daughter, even by his own admission, her boyfriend, son-in-law to him, and their child that would have been a victim. Number 8, the defendant before trial and sentencing failed to comply with the conditions of a sentence involving release into the community. He was on bond. We had to revoke his bond because he continued to commit offenses. And then number 10, I would argue that that would apply. He had no hesitation about committing a crime when the risk of human life is high. When you grab a weapon, any training I've ever heard of, at least, they tell you, you better, if you're going to pull it, you better be prepared to use it. And there's only one reason to use it, and that's to defend yourself. And usually that's going to be taught to you that you in the threat, which usually means you try to kill that person. So I would argue that would apply. Number 9, maybe, but since the element of the offense includes a firearm, I'm not sure that would apply because it's part of the elements of the offense. But other than that, I think at a minimum, I think he served 6 months, at least split to serve 1. But I mean, I understand the court's position and to serve the whole 6, given what he's done in his past. And I'm glad he's sober and everything else, but you can't run away from what you've done and what that has a consequence on of what you've done right now. So I'll leave it to the court's discretion.
Connor, we're here today for a sentencing hearing, which we were expecting, and it wasn't until I showed up in which all of a sudden I wasn't expecting to have a sentencing hearing. As Your Honor said, he normally doesn't get in the middle of these things, and as I was preparing my sentencing memorandum, the biggest thing that stood out to me was the same thing that stood out to the court, is the large criminal history. I remember going through everything myself. Let's count these one by one. And I think I counted 40. I don't know if I miscounted, but obvious, it's real. And whether it's 40 or 30, it's still something that the court has a duty to protect the community. So coming in here and asking for probation from the beginning was definitely something that I had to find a reason of how do we get there. And we saw that Mr. Henderson's criminal history largely stopped in 2015, up until this recent. Put it in my sentencing memorandum. Told us today his son died in 2019. Hot and heavy again. He started committing these crimes. Through his own admission, he knew that the only way he had any chance of stopping committing crimes and even having a potential chance of living and having a decent relationship with his family was if he stopped drinking. I know his bond was revoked. And it wasn't his attorney at the time that it was revoked. But his arrests were July of 2023, November of 2023, and then March 4th. Don't know when this case got to circuit court, but they were there a long time before this bond was revoked, and he got sober on his own. He has the ability to support himself. He was able to sell his home through his wife while he's been in custody. He does have the ability to pay court costs and court fines. This is a gentleman that my argument before the court is we ask that he be sentenced to time served. He has been in custody since March 20th of this year. However, we ask that if the court is not willing to do so, that the court exercise its authority under 4035-306 and allow Mr. Henderson to serve 1 year of a sentence with split confinement, where he will get credit for the time he has already served, do approximately another 6 months, and then have the remainder of his sentence suspended. There's no statutory authority that prevents him from being sentenced under split confinement, and we ask that the court allow Mr. Henderson the opportunity to build on what he has already taken his own initiative to do with regard to his sobriety, to continue on with that sobriety, and possibly live out the rest of his life as making amends for his past wrongs, which he has acknowledged. He has an ex-wife that he hopes to reconcile with, and obviously, as the court heard today, he has some children he needs to reconcile with as well. So he asks that the court grant him mercy. He asks to be permitted to serve. He asked for credit time served, but the court has already acknowledged that the court wasn't willing to do that, at least without hearing more. I don't know if Mr. Henderson has pushed the ball in any particular direction. but I think at a minimum, a split confinement sentence is appropriate in this case.
Anything else, Mr. Willoughby? All right. As I said before, it's rare that I will interject myself into an agreement that the state and the defense had arrived at, but this is a different scenario. Most of the time, these plea agreements are made because parties get together during discovery, and that's what that takes place. And before any entry of judgment takes place, they come to an agreement, and I always tend to defer to the state and to the defense because they know their case better than I do. They know the pluses and minuses, and they know that you're always taking a chance with a jury. This is a different kind of case. In this case, as is often the case, someone entered a plea, Mr. Henderson entered a plea to specific offenses. He pled guilty to these offenses and requested a sentencing hearing. For that reason, it is, while the state can make recommendations, it is this court's obligation and part of my responsibility at a sentencing hearing to set the sentence that I think the defendant deserves and is justified under the facts and the law. And for that reason, I took the position that what was suggested to me, in my opinion, after reading through the pre-sentence report, was not an appropriate sentence for the type of situation that we had in these three cases. So, in any event, this case comes before the court, and the court's required to follow the law. I cannot just set a sentence that I think I want to. In other words, I can't just pick a number and say, this is what I think the defendant ought to get. I'm required to follow the sentencing considerations and guidelines that are set forth by our state legislature in the Tennessee Code. Those sentencing considerations are set forth in 4035-103 of the Tennessee Code, and they include the following. To implement the purposes of this chapter, the following principles apply. 1, sentences involving confinement should be based on the following considerations. A, confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. I counted up the number of prior convictions, many of which are traffic related, but they are nonetheless examples of the defendant failing to abide by society's standards of law. And therefore, I do find that there is a lengthy history, a long history of criminal conduct. B, confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrence to others likely to commit similar offenses. 3 of these cases involving aggravated or attempted aggravated assault, and that was an agreement. They reduced the charge down from aggravated assault to attempted aggravated assault. So Mr. Henderson's already had the benefit of his lawyers arguing on his behalf and the state's giving him the benefit of the doubt. But I would simply point out that in the indictment that led to those 3 attempted aggravated assault cases, there were 3 counts. Counts 1, 2, and 3 were actually aggravated assault while displaying a weapon. Count 4 was possession of a firearm. Count 5, 6, and 7 were reckless endangerment, all felonies involving a deadly weapon. And count 8 was possession of a weapon while under the influence. The state, and I understand why, they agreed to dismiss counts 4 through 8 in that indictment and let him plead to simply 3 simple attempted aggravated assaults. So it would not be accurate to say that Mr. Henderson already has not received the benefit of an advantage in the fact that those charges were reduced and many of them were dismissed before it came to this sentencing hearing. C, under this statute, going back to the statute, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Clearly, he has a long history of probation. He has a long history of the fact that even though he received probation, or a slap on the wrist, if you want to say that, then under those circumstances, he, in this court's opinion, didn't learn his lesson. I know he's saying now that he's learned his lesson and he's going to quit drinking. Well, all I can say is that he's a little late coming to that conclusion with, by my count, 40 or 41 convictions, all of which probably were included or caused by his consumption of alcohol. Sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences that are unrelated to the purpose of this chapter should be avoided. The sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. The potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining sentence alternatives or length of term to be imposed. Trial judges are encouraged to use alternatives to incarceration, which include requirements of reparation, victim compensation, etc. So those are the sentencing considerations that I am required to consider, and I have considered those, as I've stated, in doing that. As was pointed out, he has been convicted of a Class C felony, which carries 3 to 6 years. That's the possession of a firearm by a convicted felon. Each of the attempted aggravated assault, or each of those attempted aggravated assault cases and convictions are Class D felonies, and those carry 2 to 4 years because it was part of the agreement that he would enter it as a range 1 offender, meaning that even though he has these other lengthy, most of them were misdemeanors, and so therefore I don't think he qualified to be bumped up to a range 2 offender. So the sentence range on the DUI is the 4th offense, and that carries 1 to 2 years with a mandatory minimum of 150 days. So looking at those ranges and considering those factors, I will then move to the enhancement provisions that the state has argued. Enhancement provisions are set forth in 4035-114. The first enhancement provision that this court finds to be applicable is that 1, the defendant has a previous history of criminal conviction or criminal behavior in addition to those necessary to establish the appropriate range. The second factor that this court finds to be applicable is that the offense involved more than one victim, especially so in the aggravated assault or attempted aggravated assault charges that we have today, that there were multiple victims in that particular episode. The third factor that this court finds to be applicable is that the defendant before trial or sentencing failed to comply with the conditions of a sentence involving release into the community, and the court does find that his bond was revoked because he committed these 3 offenses. And I know Mr. Montanito is trying to represent his client adequately, but the argument that, I mean, the fact that one was committed in this month and then a few months later another offense was committed, and then while he was on bond for those 2, a third of series of more serious offenses were committed, or actually I think I may have reversed it time-wise, more serious ones were committed early, and that the driving under the influence charge was the ones in March of 2024. So the fact of the matter is that he clearly, in my opinion, failed to comply with the conditions of release, so that was as well apply. I do think that enhancement factor number 9, that the defendant possessed or employed a firearm, explosive device, or other deadly weapon during the commission of the offense, that is a part of the elements of the crime of attempted aggravated assault in this court's opinion, and therefore I could not consider that. Moving to the mitigating factors to consider whether or not there are any such mitigating factors. The first mitigating factor is that the defendant's criminal conduct neither caused nor threatened serious bodily injury. Clearly, that has no application. I think it's disingenuous for Mr. Henderson to say that he had a pistol while he was heavily intoxicated and that there was no threat, no real danger to anyone. I kind of grew up with the same way. You pull a pistol on somebody, you need to be prepared to use it. There are no other factors that I could find that was, I mean, I suppose you could say that number 6, the defendant, because of youth or old age, lacks substantial judgment. He's not that old, and he's not, in my opinion, that lacking in judgment other than his use of alcohol. So I don't find any other factor that I've considered all of the factors for mitigation, and I don't find that there are any of those that would be applicable. So, in this court's opinion, the appropriate sentence range in the charge of being a felon in possession of a weapon, which is a Class C felony, this court finds that the appropriate sentence range is 3 to 6, and the court finds that with all of these enhancement provisions, that the sentence should be set for 6 years. As to the 3 counts of attempted aggravated assault, carry a sentence range of 2 to 4 years. This court finds that in each of those cases, that the threat of danger and harm to the individuals that were there, including his own family members, was so significant and so severe under the circumstances that it would justify the maximum sentence of 4 years on each of those counts. And on the driving under the influence of an intoxicant, 4th offense, this court finds that he should be sentenced to 1 year to serve as well. The sentences that this court has imposed also come under the provision of a 40, 35, 115, which are multiple convictions. If a defendant is convicted of more than one criminal offense, the court shall order sentences to run consecutively or concurrently as provided by the criteria in this section. Subsection B, the court may order sentences to run consecutively if the court finds by preponderance of the evidence that 1, the defendant is a professional criminal who has knowingly devoted his life to the criminal acts as a major source of livelihood. That does not apply. 2, the defendant is an offender whose record of criminal activity is extensive. The court finds that does apply. 3, the defendant is a dangerous, mentally abnormal person. I do not find that. 4, the defendant is a dangerous offender whose behavior indicates little or no regard for human life and has no hesitation about committing a crime. I do not find that. And as a result of that, I've looked at all of the other, most of those involve sexual exploitation or sex offenses, multiple sex offenses. So based upon the fact that he is an offender whose record of criminal activity is extensive, but as I've stated, I've considered making these run consecutively, which would be, if I ran the 3 aggravated assault convictions consecutively, that would a total of 12 years. I am not going to do that simply because of the fact that, in my opinion, his record of criminal activity is extensive, but that there is mostly the great majority of them are traffic offenses and other matters so it's not, there's only a kidnapping charge that causes me concern. And without more knowledge about what happened in that situation, I don't feel comfortable with that. So I am ruling instead that he should serve 6 years on the 1 count, 4 years on each of the other 3, and the 1 year on the DUI. All of those will run concurrently with one another for a total of 6 years to serve. That's the judgment of the court. He's remanded to begin serving his sentence. He will get credit for time served.